Good morning. Welcome to the First District Court of Appeals. We have two cases scheduled to be argued this morning. When I call your case, please stand, state your name, the party you represent, and your readiness to proceed. The first case is C-24-0381, State of Ohio versus Jada Terry.
Good morning, Your Honor. Sarah Nelson on behalf of the Terry.
Good morning, Robert Wessels on behalf of the State.
Great, thank you. And the second case is C-24-0379, C90 Limited versus Christopher Ritter.
Good morning, Your Honors. Justin Whitaker for the appellant, Rare Beast Limited.
Good morning, Your Honor. Kevin Hoskins on behalf of the appellees.
Great, thank you. And we'll begin with the first argument, State of Ohio versus Jada Terry. Ms. Nelson, you may come forward. Would you like to reserve time for rebuttal?
Yeah, 3 minutes, please.
All right.
Good morning, Your Honors. May it please the court. Good morning, opposing counsel. Sarah Nelson again on behalf of Ms. Terry. This case, we have 3 assignments of error in this case. The sentencing issue, the third assignment of error, I am going to submit on unless the court has any questions and focus on the first and second. This case concerns a conviction for obstructing official business, and it's our position that that conviction was not supported by sufficient evidence. Ms. Terry did not engage in an affirmative act when she refused to step out of her vehicle, and providing a false name during the traffic stop in this case did not hamper or impede the officer's investigation. It did not create a substantial stoppage. Regarding the affirmative act requirement, this court has said that a person can't be guilty of obstructing by doing nothing or failing to act, and it's our position that that's what Ms. Terry did in this case when she remained seated in her vehicle and didn't step out as ordered to by the officer.
There is case law that verbal conduct, to the extent that's not an oxymoron, can constitute an affirmative act. Can you address whether her verbal comments to the officer during the interaction would satisfy the affirmative act requirement?
My familiarity with the verbal conduct comes from a 5th District case that is escaping me from 2024, where in the 5th District, and I believe this 11th, they do say that some sort of verbal exchange with an officer can give rise to an affirmative act. That case also contemplated a failure to act. The defendant in that case sat in his vehicle during a window tint violation, so it's similar, and it was verbal conduct needlessly escalating the situation, needlessly stalling. So I think it's not applicable in this case because this court has said the failure to act doesn't amount to an affirmative act for purposes of obstructing official business because we don't follow what the 5th District does. 5th District says if you needlessly escalate the situation, or you needlessly, have this verbal exchange, if you're not doing anything by sitting in your vehicle and not following the command, I think it's irrelevant, the back and forth that they're having. Not only that, but the back and forth that they're having in this case has to do with why am I being asked to step out of the vehicle? Being advised that you're under the arrest would change, I think, my position on that because she wasn't advised that she was being arrested for about 2 minutes during the verbal back and forth.
Is the officer not allowed to order somebody out of a vehicle during a lawful traffic stop?
They are.
Okay.
But I don't think that carries the day in this case. I cited a 3rd District case. I think it's State v. King, and at paragraph 58, they list a number of things that have been held to not constitute an affirmative act based on the failure to do things. In multiple instances, they were lawful orders, like fingerprinting. Somebody was ordered to be fingerprinted, and they refused. Ordered to pay fines, and they refused, or to sign an order agreeing that you would pay fines. So there are certain situations where police or law enforcement are asking you to do something under appropriate lawful authority, and your refusal to respond or act in response to that command doesn't give rise to an affirmative act for purposes of obstructing. So I think that's what we have here. Sitting in your car, not getting out per the command is an inaction that doesn't amount to an affirmative act.
So would you equate what occurred here, because she's sitting in the car, not getting out, but then she's also saying things, would you equate this to a situation where she just sat mute and didn't get out of the car? Is it irrelevant that she's also saying things?
I think it's irrelevant that she's saying things. She's not combative, she's not abusive to the officer, she's just asking why is she being asked to step out of the vehicle. If she were being more abusive in her language, I might have a different response. But under the circumstances of this case, the exchange is just, why am I being asked to step out of the vehicle? There is clear concern and hesitancy for her personal safety and circumstances, given her pregnancy, acknowledgement to the officer, and the fact that her kids were in the car. So we're not dealing with somebody who's being particularly combative and putting the officer's safety at risk, but somebody who is concerned for their personal circumstances and wanting to know on what basis is the officer asking me to
Well,
step out of
does
this
the
vehicle.
affirmative act requirement come down to the person's motivation?
Well, I'm drawing on the Fifth District case, right? And it's this, this argument, I believe in that case, it was an argumentative, combative situation between the officer and the driver, which I don't think we have here. And that's my comparison. If there's other case law that says it doesn't matter, then I'm respectfully not familiar with it, but I don't think that this case, because of the First District case law that says the failure to do something by sitting in your vehicle, we don't have to worry about the
Did
conversation.
I hear you say that things would be different if the officer had told her she was under arrest?
Yes,
Okay.
he did advise her roughly 2 minutes into their exchange when he returns to the vehicle. But that's over 3 minutes total. For the first 2 minutes, she's asking, why am I being asked to step out of
So
the vehicle?
if he had told her why?
Right away,
And then she still refused?
different.
Different thing.
Yes,
Okay, so it's all based on the fact, your argument's based on the fact that the officer wouldn't answer her question? I mean, and she just sat there and continued to say, why am I being ordered out of this vehicle?
right. The sitting in the car and not following the command is the inaction that I'm speaking to.
And why would it be different? I mean, what I hear you to be saying is that merely sitting in a car and not getting out, whether you're speaking or not speaking, that doesn't constitute an affirmative act because that's inaction. That's what I hear you to be saying.
Yes,
And why would that change based on an officer saying you're under arrest as opposed to saying I'm ordering you out of a car?
the arrest is a fact that seems significant in State v. SJ and in State v. Carrion. And that's why I make that distinction. In State v. SJ, there was no communication about you being under arrest. And in State v. Carrion, police were at the defendant's house to execute a felony arrest warrant. So different set of circumstances that, in both cases, the fact of the arrest and the knowledge of the arrest was significant. So the lack of the arrest for a majority of their interaction, or the lack of communication about the arrest, I think is significant, just based on
Doesn't
how
that go
plays
to
out.
the official duties element that the officer is there to execute as opposed to what constitutes an affirmative act? I guess I'm struggling to understand why action versus inaction would change based on what the instruction is.
I don't mean to confuse the issues. I will redirect the comment because the officer in this case didn't testify to her verbal back and forth as the basis for the obstruction. Just to quickly note that, because he said that it was based on the false name and her refusal to get out of the vehicle. So I'm not considering the verbal back and forth because it doesn't seem to have played into the officer's charging decision and what he testified to at trial. But I also think that the verbal conduct is a nuance that plays out in the Fifth District case law and not the First District case law. And what we have in the First District is like black letter law, failure to act or not obeying a command is not obstructing. And we don't consider the circumstances necessarily surrounding that failure to act. We just know that you're not following the command.
Can you address the second issue on
Yes.
whether the officer was hampered or impeded?
Yes, so the hampering and impeding stems from the giving the false name, which is something that we need to consider in this case. But the case law bears out that giving the false name, as long as it doesn't force the officer to have to engage in further investigation, it's not something that necessarily constitutes hamper or impeding.
Didn't he have to engage in further investigation to figure out that it wasn't her?
No. Respectfully, he said in this case that he did nothing in addition to that he would have otherwise done during a traffic stop. So he stops the vehicle, pulls up the registered owner's information prior to even approaching, and then runs the name that he was provided and compares it to the registered owner. He doesn't say that that action was an additional step. He said that he took the same steps that he would have taken in any traffic case. So the false name nuance in this case doesn't create a substantial stoppage.
The body-worn camera footage was admitted, correct?
Correct.
And it was fully admitted, it was not for a limited purpose.
I believe that's correct, although I don't think portions of it were played beyond her stepping out of the vehicle, but to the extent that it was fully admitted, I think that's correct.
And so are we permitted to consider what the officers discuss on the body-worn camera footage? Is that evidence in the case?
Yes, I suppose.
All right, on the body-worn camera footage, the officers indicate that they are, well, the first officer, the arresting officer, indicates that he has ordered her out of the vehicle because she gave a false name. And then later in the encounter, he indicates, and so does the female officer who later arrives on the scene, that they would have let her go had she not given a false name. So it appears from the information that the officers are providing at the scene that the traffic stop and the arrest was prolonged because of the false name that was given, to the extent that she was ordered out of the vehicle on that basis and that she was ultimately arrested on that basis. How do you take those actions into account in considering whether the officers were hampered or impeded?
I respectfully say that that characterization of what happened is inconsistent with how the officer testified and described the events in this case. So we're interpreting the video in a different way than how the officer testified. And the evidence as provided by the testimony was that his traffic stop wasn't prolonged because he didn't engage in additional actions that he wouldn't otherwise have done during a normal traffic stop. And he agreed that this was generously a 5-minute stop that was impeded by the failure to get out of the vehicle. That was his testimony. So as far as the giving the false name, the case law even says that that action by itself doesn't necessarily impede an investigation unless it causes the police to go out, like for instance, the Ohio Supreme Court case that was cited, Lazaro, giving false names regarding witnesses to an event that weren't actually witnesses caused problems for the police because then they had to start over. The names that you gave us weren't true. We need to come back and revisit this. That's
Why
not what
was he
happened in this
ordering
case.
her out of the car? What is your understanding of the evidence on that point?
The false name, I believe, is why he was ordering her out of the vehicle, but the investigation into that offense, that action, didn't unnecessarily prolong the proceedings. If I may briefly turn to the second assignment of error, the claim that Ms. Terry's due process rights were violated in this case. Because if this court ultimately finds that the evidence is sufficient, we're still asking for reversal on a due process violation and remand for a new trial. After the body-worn camera was played and before the officer had a chance to even testify factually about the events that happened on the body-worn camera, the trial court pulled the parties into chambers and had an exchange about the merits of the case. And it's our position that this exchange shows a bias, that the judge prejudged the case before the full testimony was elicited, before cross-examination had even occurred. And when judicial bias is apparent or it's compelling under the circumstances, reversal is warranted. If there are no questions on that issue, I'll reserve the remainder of my time for rebuttal.
Thank you.
Thank you, and may it please the court and opposing counsel. I will point out for the court that as at least to appellant's third assignment of error, the state is conceding error, if there are no questions about that. I guess first I'll ask if the court has any immediate questions. I know there was a lot of questions posed to.
What is your perspective on the body-worn camera footage? Is that video fully in evidence for its truth?
I believe so, and to be frank, I didn't review the transcript before closely enough to see whether they had indicated specifically. I do believe there are some references to time portions made by the prosecutor who was admitting the evidence, but I don't know to what extent the court indicated which portions. And I do believe the whole of the video was admitted. To that extent, I do believe that the court can consider it, at least as to what you were referencing, Judge Kinsley, at least one of those statements made by the police officer, the arresting officer who was speaking about his reasoning. I do believe at the very least that first statement, I'm almost certain, was admitted, and I do think the transcript backs that up.
And that statement that we're talking about is the one where he is in his cruiser and he says, I'm going to get her out because she gave the false name.
Right, I mean, at least for the purposes of the second element of the first assignment of error, that whether or not there was some prolonging of the time for the officer pulled over the car for speeding. To the extent that the investigation was prolonged, if we're looking at those false statements as a either an overt act that caused him to impede or hamper his official duties, it seems to me that without those statements, he would have given her a speeding ticket and moved on. Now, obviously,
And later on, he does in fact indicate that.
right, that's what I believe chose. The reason, my understanding, and this is what she told officers, the reason she gave that false name is because she was operating under a driver's license suspension. So ultimately, I think, at least to what opposing counsel was referencing, had he run her actual name, he would have determined that she was driving under a license suspension. As I understand it, there's nothing in the record that would indicate that he would have necessarily arrested her on that offense. It's not generally an arrestable offense, as I understand it, driving under a license suspension. But then again, I also don't know what type of license suspension she was operating on. I don't think that's in the record.
Right, and he does speak to that, as does the female officer, and they both indicate to her that she would have been able to call someone to come pick up her car and pick up her children, and that she would have been cited and gone on her way.
I think there's a framing, and a lot of this speaks to, I think, the difference that opposing counsel and I have of the actions of the police officer in this case, and to whether or not what they did was appropriate. As the court has pointed out, even if there wasn't, for example, probable cause to arrest on that false statement, an officer is allowed to ask someone, is allowed to give a lawful order for any lawfully stopped vehicle to have that operator step out of the vehicle. So I think it's been conceded that the officer was acting within the bounds of the law, whether for an arrest purpose or for, I think, to get her out of the car as the operator.
Is there anything in the record that would explain or indicate that ordering someone out of a vehicle hampers or impedes what would be an ordinary traffic stop?
To the extent that I guess if I'm understanding your question correctly, if an officer pulls over someone, say, for speeding and says, and we don't even have any sort of false statement, it just says, I need you to get out of the vehicle, and they refuse to, whether or not there's anything in the record to establish that that alone is sufficient to hamper. I think the answer to your question, I think, goes to what I believe is established by this court. There were some questions specifically made as to whether purely verbal content can use to hamper a police officer's ability. This court in 2023 in the Carrion case cited in our brief said that an affirmative act is defined as any conduct, physical or verbal, that hampers or impedes the officer in the performance of his or her duty. Obviously, I think there's different fact patterns that could exist, but to the extent that someone is either too combative or continuously, I sit and think about a position where someone is inactive and just will sit in their car and go limp and just refuse to get out of the car for an hour. I mean, certainly at least as to that hamper or impeding element, I think absolutely. And at which I think maybe there was some confusion, or maybe not confusion, but the concepts of whether there was an overt act and whether there was hampering, impeding, I think is inherently tied into this case in a peculiar way, because below, the defendant's counsel argued that if this was the overt act, then there was no hampering and impeding, and maybe there was hampering and impeding but this wasn't an overt act. And so I think that's maybe where some of the confusion is coming in here, at least as I understand the defense's argument below. Ultimately, though, I think that question is more thoroughly answered by the case law that we have in this district. Recently in State v. Hammock, this court said that the totality of the defendant's conduct should be considered as opposed to viewing each act in isolation when reviewing an OOB. So I do think when we're considering what took place here for the purposes of an OOB, we can consider both the actions that she took in refusing to get out of the vehicle and the lying to police officers.
Do you agree with the appellant that the officer testified that this didn't hamper or impede the false name? Like, that he didn't do anything else differently?
No, I think that obviously I don't, well, I have it back there, but I don't recall the officer's exact testimony, but my understanding of the officer's testimony is that the whole of the circumstances, the lying to the police officer and also the refusing to get out of the vehicle is what hampered them in their duties. In this case, at the very minimum, getting her out of the car was within that range of allowable duties of that officer.
And it seems like, I mean, she kept asking him why, and he wouldn't tell her why, which seems to kind of have caused her to not get out. It just, it just seems it would have been a little easier if he would have just said, hey, you gave me a false name.
And that could be true. And he did say when he walked up, he called her by her real name. I think maybe at that
Yeah.
point that the jig was up. But ultimately, I think what you're getting at, opposing counsel has framed it as this was not combative. This was her just trying to be concerned for her safety. But ultimately, that's either a factual or a credibility determination for the trier of fact here. Obviously, the court could have said, yes, she was just concerned with her safety. But I think the court's determination of her intent, and Judge Kinsley, you asked a question about here whether the motivation matters. I do think it matters, at least for the mens rea of this element, whether she was actually intending to impede. And that, I think, can be inferred through, as we've been talking about, the totality of the circumstances. I do not think that the only reasonable interpretation is that she was just concerned for her safety, concerned for her kids. That could be.
She could have had multiple reasons.
Sure.
She could have been afraid.
Right.
She could have had a fight or flight reaction. She could also have realized, as I think she mentioned later in the video, that she was likely to face some legal problems because of her suspended license.
And obviously, that's a scary situation to be in when she's got her kids in the back seat, and she knows that, at a minimum, she has to reveal to the officer that she's driving under a license suspension. But even so, again, I think this, while that could have been a determination for the trier of fact, I don't think it's a determination that was made here. I point this out in my brief, but I'll reference it again here because I don't believe it was addressed sufficiently here during oral arguments. I do believe, and the judge did say, that you can see her pulling away from officers as he has her hand on her, attempting to remove her from the vehicle. That happens throughout the course of what I would describe as her refusal to exit. So our position is that this does go, whether verbal or physical, goes beyond what I would describe as a mere inaction. I do think, taken together, her actions evidence her intention to hamper or impede the officer's ability.
And so is it the state's position that, in addition to what may have been argued at trial directly, that we should also consider that pulling away conduct that's visible in the video?
Right. I think, yes. I think that, at least in opening statements, I think there's maybe some discrepancy between what the state argued in opening and what argued in closing. But I think that's consistent with what happens in trial. Sometimes things come up. And I do believe in closing, the state prosecutor argued that both the physical and verbal conduct taken together could indicate that OOB. In relation to, unless the court has any more particular questions onto the first assignment of error, as it relates to the second assignment of error, I don't believe that the appellant has met their burden of demonstrating that there was any bias in this case, to the extent that this court may or may not find that they've weighed that issue on appeal.
There was no objection at the time contemporaneously, right?
Correct. There was never any objection that there was some sort of unfairness or bias that was evidenced by those statements. In fact, the appellant's counsel, as I understand it, seemed to, by the time they went back to talk in chambers, seemed to agree with what the judge was saying, which was, yes, Judge, we understand that a great majority of the facts in this case aren't in question. Let me back up. The judge says, well, she's pulling away from him here. What's going on? Why are we having a trial? And defense counsel says, well, it's not really so much that the facts are at issue here as much as we want to make sure we can make our legal argument as to what those facts show. So, and frankly, other than that one statement, there's nothing in this case that I think demonstrates the kind of unfairness or bias that would result in a due process violation. It doesn't, in fact, as I argue in my memorandum, it appears that the judge seemingly agreed with what was ultimately the legal argument of opposing counsel, which was that this false statement may not have been in itself the overt act, and which is, as I read the court's explanation of its conclusions, that it was finding the whole or the totality of the circumstances to be this overt act for the purposes of an OOP. Unless the court has any more specific questions of me, I don't believe I have anything else to add. Thank you.
Thank you.
Try and make a couple of quick points. Regarding the carry-in case and the fact that the defendant in that case told the police to hold on, that comment was made in the midst of him being physically arrested by the police who had entered his home. Quite different than the situation we have with respect to the speech, the exchange of, the conversational exchange that happens. If this court is going to go down like the speech question, what is the effect of her having this communication with the officer? I would caution the court to pause for two reasons. One, I believe that it's really more abusive language, combative language that would carry the day in terms of whether or not speech can constitute an obstructing. And also, it wasn't raised below as part of the circumstances that led to her obstructing charge. As the court pointed out, and the complaint indicates, this all stems from her initial failure to give a correct name. Regarding
And counsel, question for you. On the body-worn camera footage, it shows that the officer, when he pulls up to the car, has somebody's picture and information on the screen already.
Yes.
Was that the correct information for the owner of the vehicle?
Yes, it's my understanding he pulled up the registered owner's information before even approaching. So he had Miss Terry's picture and information at the ready when he came back and double-checked the name that she provided. So there was no additional steps taken. He did what he would have done in every traffic situation, which is testimony that came out on cross-examination. So to the extent that I misled the court in saying affirmative testimony was a conversation that happened during cross that I believe suggests that he didn't do anything different. And finally, I wanted to point out that the pulling away comment in this case, that Miss Terry physically resisted the police. Like, one, she wasn't charged with resisting arrest, and two, I believe that observation is made by the trial court in the discussion about why are we having a trial. And that's, again, why I raised the second assignment of error in terms of potential bias and prejudice in this case, because he's clearly making assumptions about what's happening in this case prior to the officer even testifying, and I don't believe the officer in this case described Ms. Terry's conduct as pulling away or being combative at any point.
So this was a situation where the judge stopped everything and had everybody come into chambers
Correct.
to ask this question of why we're having a trial?
That's correct.
Okay.
He asked it twice. The first time the prosecutor responded, I'm not sure, I think it's pretty cut and dry, but then he asks it again. He's emphasizing, why are we here? And that's when the defense counsel, to the extent that she should have answered, my client has a right to take this case to trial, and said they have a discussion about the merits of the case. What we learned from this conversation, though, is that there is some the court is doing some prejudging the case on a factual basis based on the body camera alone. And things like pulling away wasn't actually testified to by the officer, if I recall the record correctly. That's his characterization. I don't think the testimony supports it, which is why I think that there is evidence here that that prejudging the case during that conversation leads to judicial bias. And if this court is not inclined to reverse on sufficiency, then we respectfully ask to reverse for a new trial. If there are no further questions, thank you.
Thank you. We'll take the matter under submission and issue a timely decision. Thank you both for your arguments this morning. The next case on the docket is C-24-0379, C-90 versus Ritter. Mr. Whitaker, you may come forward. Would you like to reserve time for rebuttal?
Yes, Your Honor, 5 minutes.
Right?
Thank you.
You can begin when you're ready.
May it please the court, opposing counsel. My name's Justin Whitaker. I'm here in this matter on behalf of the appellant, Rare Beast Limited. To give some context to the case, this was a mundane civil business dispute started in the Court of Appeals by my clients, C90 Limited, and two of the company's three members. Discovery proceeded, depositions were taken. All the parties in this case were deposed at the last minute. Mr. Ritter, who's a defendant in the case below, elected to issue a subpoena to Rare Beast Limited, which is the new company that two of the members of C90 started after Mr. Ritter, who was the third member, resigned in 2023 and decided to compete with C90 with a former employee of C90 while he was still employed by C90, while he was the CFO of C90, while he was the treasurer of C90. In his capacity as the treasurer of C90, before he quit his job at C90, he informed the other members that the company was hopelessly underwater. There was no income. After they made their payroll that month, there would be maybe $500 for each of the three members. He testified during his deposition that he knew at the time that C90 was hopelessly financially ruined at that point. And before that point, he elected to compete with C90 with the former employee by using C90's work product, its contacts.
So is C90 essentially defunct now?
C90 dissolved in the summer and fall of 2023.
Okay, and Rare Beast is a new entity.
Completely new entity, completely different business, completely different members. While it is true that two of the members of C90 are also members of Rare Beast, there are 5 other members of Rare Beast that have no connection to C90, no connection to Ritter or Summers, and no connection to the previous business of C90. They're different businesses.
But the judge joined them.
The judge did join them.
Okay, so now they're a party in this case.
They are a party to the case.
And the subpoena that is at issue here, is that still something that it has to comply with now that it's a party?
Well, that's the problem that we face, Your Honor, is that there was no hearing on the subpoena. When the motion to quash was filed, the primary basis was trade secrets. The Ritter is asking for, from a non-party, its primary business contacts and relationships and contracts.
But now that it's a party, like what happens to the subpoena? Does it go away and then the regular discovery rules come in play?
I
or-
don't think so, Your Honor, because what Judge Wagner did was an end run around Rule 45C, the protections of a party, of a non-party to a case.
So Rare Beast, you think, still has to comply with the subpoena?
I don't think so, Your Honor.
Okay.
I think.
Isn't the subpoena at this point, since they're a party, isn't the subpoena kind of immaterial?
I don't think so, Your Honor, because the protections of a non-party were under Rule 45C were avoided. There was no hearing and there was no.
So do you think those protections are more robust than those that would be afforded to a party in a production of documents? I mean, won't they just assert the same entitlement to have their trade secrets protected?
As a party under Rule 34, certainly the scope of discovery is similar under Rule 45 and Rule 34 as it relates to Rule 26. So the scope of discovery is obviously similar.
And the judge never got to what was or was not a trade secret.
Correct. There was no hearing and no in-camera review.
So you still have that opportunity below, theoretically.
Theoretically, if Your Honor, if the Court of Appeals agrees on appeal that we should have had a hearing or in-camera review of those materials.
What enforcement mechanisms exist for this subpoena right now, today? Like, let's say that we were not in the Court of Appeals, you were back in the trial court. How would Ritter enforce this subpoena against Rare Beast today?
If we weren't in the Court of Appeals, I don't think I know the answer to that question, Your Honor, because Rare Beast was joined. And if there was no appeal, then Rare Beast would simply be a party, I believe, and subject to Rule 34.
So the subpoena is not enforceable, that's your position?
If there were no appeal, certainly there would be no more subpoena,
Why isn't this case moved?
because Rare Beast wasn't afforded the protections of a non-party under Rule 45C. Before Judge Wagner sort of unceremoniously resolved the issue by saying, well, we'll just join Rare Beast and we don't have to worry about its rights under Rule 45C.
But the documents haven't been turned over yet, right?
Some documents have been turned over, well, some.
The trade secret, the ones that you're claiming are trade secrets, haven't.
Correct.
Okay.
Correct, Your Honor.
So that is still something that you can litigate as a party now in front of the judge.
It is something we could litigate. However, we go back to the protections of a non-party. The documents requested of Rare Beast via subpoena were of Rare Beast, a non-party, and its communications and contracts and other information with another non-party, its biggest client. And that's important because we already know that Ritter and Summers wanted that information to compete with C90 that has no connection to Rare Beast.
Did C90 have a connection to that other client, though?
Months earlier. And
Isn't the whole idea that they're kind of competing for that same business and?
well, C90 and Rare Beast are two different companies with two different business models and businesses, period.
But what was Rare Beast going to do differently for the client that they were in competition with Summers and Ritter?
Well, Rare Beast is a publishing company primarily, but it certainly does this uses similar digital tools and marketing that C90 did, just by virtue of the fact that a lot of what they both did was digital.
Was there a motion pending to make them a party? Or was it something the judge just did basically in response to the dynamics of the hearing?
There was a motion to join Rare Beast, which was filed a day before Rare Beast's deadline to comply with the subpoena, which was also 2 days before the discovery deadline expired. So,
But adding them as a party basically extended all of the discovery, right? Or theoretically would.
it theoretically would if there were an order, but there was no order. There was no motion to compel any of the information that was still outstanding. It was done via subpoena of a non-party to get at the non-party's relationship with another non-party.
Is there a request for production of documents now pending against Rare Beast?
I believe some have been tendered, but that would have been
Basically asking for the same stuff, right?
yeah, they were tendered, I believe, before or after the hearing.
So theoretically.
But after or before the motion or the notice of appeal was filed.
Right, so Rare Beast can lodge the same objections to the secrecy of the documents when it responds to the production of documents?
It theoretically could if Judge Wagner hadn't already ruled that they be produced. So
He didn't actually rule that, did he? I mean, he just
he denied the motion. to
denied,
quash.
right? And we don't exactly really know why.
That's the other problem. There was no specificity in the order. There was no,
And he did that at the same time that he made Rare Beast a party.
Yes.
And then he said, come back to me if you have a discovery problem, right?
yes, and the discovery problem was what we were talking about at the oral argument, which was Rare Beast has rights as a non-party under Rule 45C that afforded more protections than a party under Rule 34. And the court's solution to that was to say, fine, we'll join Rare Beast, and then we don't have to worry about Rule 45C. And if that were permissible, then that would render Rule 45C irrelevant and moot and surplusage if a party could just be joined without a hearing, without an in-camera review.
We can't rule on that issue. I mean, you're not appealing the joinder. I mean, that we
No,
can't
that
rule
would
on
not,
that.
that wouldn't be immediately appealable. But
Right.
the result, they happened at the same time, and the result is the same. We're appealing.
But like, I guess I don't understand what we're to do with, if you're saying the subpoena is not enforceable and now you guys are a party and you could litigate the same trade secrets issue. I'm trying to figure out what you're asking us to do.
At the very least, there should be an in-camera review or an evidentiary hearing of the materials that were requested via the subpoena.
But isn't he gonna do that when you argue the trade secrets as a party? I mean, can't you, that's what Judge Nestor just asked. I mean, this all can happen even though you're a party, right? If it's trade secrets.
And then you'd have an appeal if there was some adverse ruling on the trade secrets, right? Because those would still be theoretically privileged. If you got an adverse ruling in regard to a motion to compel on the production of documents.
Sure, that would result in another appeal, though, of the same argument and the same issues.
But we don't even know what the trade secrets would be in this case, right?
That's correct, because there was no.
So we
oral-
like never get to the trade secrets issue here anyway, because they were never even reviewed in camera.
Right, and as the court indicated in the Schaefer case, an in-camera review or a evidentiary hearing is mandatory when there are trade secret issues, particularly of a non-party.
And these would just be like the contacts with that, well, I guess all of their, there's going to be a very broad discovery request regarding all of their contacts with potential competitors.
Yeah, yes, I mean, the discovery requests themselves ask for each and every and all communication with all of your clients, all of your customers, all of your contracts.
But certainly, you can object to that in the production of documents and then narrow the request and then identify what you think are trade secrets.
That's true. However, under the Schaefer case, we were entitled to a hearing. We were entitled to an evidentiary hearing or an in-camera review, and we're prepared to go forward that day with the hearing. My clients were there and ready to testify. The court didn't hear it.
Until the judge made you a party,
Yes,
and that changed the whole scope of everything.
yes, without the protections
Yeah.
my clients were afforded under the rules.
What is the broader protection under 45 that you wouldn't be able to assert under the 34?
The undue burden, the requesting party is required to minimize any undue burden to a non-party. And there's case law, I think that's the right case from the First Circuit that says an undue burden or trade secrets in the compelled production of that from a non-party necessarily involves an undue burden without a hearing or without an in-camera review.
But how is that, I don't see how that's different, though, because you can still assert the privileged nature of a trade secret in regard to the production.
Yes,
So I don't see how that's very different than what you could do in a regular party discovery proceeding.
but the rule specifically requires counsel and the opposing party, the party issuing the subpoena, to actively avoid the undue burden. Whereas under, Rule 34 and Rule 26, it's not, the same active requirement isn't there. It's not even written into the rule. It's, the scope of discovery of parties is, as your honors know, is very broad.
Right.
We don't
but
think it's as
actually-
broad for.
Actually, Rule 26, though, has been narrowed, right? Like, you're supposed to have narrow discovery now that's focused on the issues, and the trial judge can fashion an order that allows the parties to reach the issues that are involved in the case, maybe limiting the access to the non-relevant contacts of your Rare Beast client contact list.
Certainly, the trial court can always fashion a remedy, a discovery order that narrows the scope of discovery. I don't know that Rule 26C materially deviates from the former relevant or reasonably likely to lead to the discovery of relevant evidence. The trial judge could always exercise that discretion to limit discovery. What Rule 45C does explicitly, though, is require the requesting party to minimize the burden of production. And none of that happened here, particularly because of the trade secrets issue, and particularly because the trial court didn't hold the mandatory in-camera review or evidentiary hearing.
Mr. Whitaker, you're out of time.
Okay, thank you, Judge.
Thank you.
Good morning,
Good morning.
counsel. May it please the court, so I had a full presentation that I was ready to give, but picking up on the judge's questions, I think the questions are in the right place. You know, first, in terms of what are they asking the court to do? You'll see in their reply brief that they actually, in the closing section, they actually asked the court to direct the trial court to reconsider its position on joining Rare Beast to the case. That's not on appeal. And there's case law from the 11th District and several other districts. The 11th District case is Kohut, which says that an order joining a party is not final and appealable, so that shouldn't be a part of this case.
Isn't the,
Go ahead.
I was gonna say, isn't the frustration that, by this maneuver, basically, Rare Beast is not getting what it would otherwise get under Rule 45, and this is really just an avoidance, like, it's like a clever avoidance, and makes what would have otherwise been something that could have been appealed, it turns it into non-appealable because it then throws it back into discovery?
On our part,
Yes.
I
I mean, yeah, I don't know when you filed the motion to join them, but it sounds like it was all coming together at one point.
It was.
And then this seems like, you know, kudos to you, a clever avoidance of maybe perhaps the consequences of the subpoena.
It really wasn't clever tactics on my behalf. What happened was I took the deposition of the principal, Mr. Jones, and Mr. Jones admitted that basically they took a customer from C90 while my client was still a member and while we still had this bank debt. And
Is that discovery geared toward that particular
it is.
contact? Because it seems like part of the objection is that it's such a broad universe of potential trade secrets. It seems like if it was more focused on that one contact, then it might be easier to resolve, whether in the subpoena or in the production.
It relates entirely to B&B riverboats, and it's for a one-year time frame. So I tried to tailor this as narrow as possible.
Is that what you said in the subpoena?
Yeah, it's in the
Okay.
subpoena. It's,
Is the subpoena even still enforceable now?
So, that's a good question.
I know.
I,
What's the answer?
looking at 45A, I don't think it is.
Okay.
And we issued written discovery after that hearing that basically, to Judge Nestor's point, asked the exact same questions.
So does the subpoena, now that Rare Beast is joined, just go away?
I think it does, because I don't think you can have a subpoena to a party to a case.
Right.
So is this appeal moot then?
I think it is, and I've tried to convey that to the council, but I feel like at the end of the day, and if you read the brief, their gripe really is about the joinder issue, which is not appealable. In terms of, and I feel like I need to address it while we're here, in terms of this idea of trade secrets, Rule 45H, I think, requires them to actually come forward with a list of their trade secrets.
And we don't have that in this record, do we?
It never happened. So we went in front of the trial judge, and the judge asked, what are your trade secrets? And he said, you know, we've actually, my client testified about the relationship with Rare Beast, and so we think it's no longer a secret. So what is Judge Wagner supposed to do at that point? I can tell you that the case law does not support this requirement. In the civil context, does not support the requirement that there be an mandatory in-camera review or an evidentiary hearing.
Right, that is as to attorney-client privileged information, correct?
That's correct, but it's also, so there's the criminal rules, I think it's Rule 17, allows for in-camera reviews of evidence that is of trial subpoena evidence, okay? Like the day you're going to trial. 45 doesn't. And there's been cases, sort of jumping around now, so I apologize for that, but
Well, doesn't the concept of trade secrets, at least by legal definition, require some showing of secrecy, some attempt on the part of the business owner to maintain the secrecy and privacy of the information?
it does. And under Schaefer, you have to make a colorable claim for a trade secret for this court to even have jurisdiction.
And can you help me understand how information that by definition would have been shared with a third party, like communication with a client, would be secret?
What we're looking for are invoices. I understand they don't at this point have a relationship with B&B Riverboats, but we're looking at we've got evidence from other customers where they told the customer it was just a name change, this new LLC that didn't include my client, that it was just a name change. What happened with B&B Riverboats that it switched from C90 to Rare Beast? That'd be helpful to know. They say there's nothing nefarious, but we don't have the documents that show what happened. The bank records showing how much was paid.
Did you subpoena that information from B&B or depose B&B?
I did, and B&B doesn't have access to those communications.
Their own communications with,
They don't. So, here we are. But, and then, for instance, the work they did for B&B, Mr. Jones testified that it was a continuation of the work that C90 was performing. That's what he testified to. In these papers, they say it was completely different. Well, it'd be nice to see what actual work they did so we can compare what C90 did for B&B Riverboats.
And to the extent they're somehow claiming that that shared work product to a third party was secret, they could make that claim in response to the discovery process at a future date, right?
I wish they couldn't. We've wasted a ton of time and expense in this process, but I suppose so.
And the judge could review that and have it in camera and do all of this process that they're requesting in theory,
I don't think he has to,
but he could.
I would invite it at this point. We don't know what they're claiming is a trade secret. And in terms of unreasonable burden, they told the court on May 7th, when we were in front of the judge, that they had all the documents ready, willing, and able to produce.
If you were, assume this appeal does not exist and you're back in the trial court, if you were going to file a motion to compel Rare Beast to disclose the documents that you want, what motion would you file at this point?
Motion to compel
Under what rule?
under, is it 20? Can't ask you yet.
The discovery rules?
you just do it under Rule 34 and Rule
34, yeah, 34.
Not a trick question, I'm not meaning
No,
to trick you,
34.
but the discovery rules.
Discovery rules.
All right, thank
Because
you.
they're a party now. So-
And then you would file a motion to compel, and they would resist and basically ask for an in-camera hearing and have to identify what they think are trade secrets. And then if there was something that they thought was so protectable that it was subject to a privilege appeal, they would then attempt to come back up here. So that whole process exists in the regular discovery course. Yes?
Correct. Curious how documents sent to a third party could be trade secrets, but
Well, they could be marked confidential, or they could be marked for your eyes only, and they could say these are, theoretically, they could qualify.
I guess they could have an NDA. We just don't know at this point. So unless there are other questions, I won't go through my whole presentation. Thanks for your time.
Thank you.
Your Honors, the appellees don't know what they're asking for because they testified in their depositions that they had no knowledge or information that anything that they were asking for existed. Ritter, and was raised on summary judgment already, which hasn't been briefed fully, but Ritter testified that he has no knowledge of C90 or Jones or Erasmus having done anything with respect to Rare Beast, transferring clients from C90 to Rare Beast. It was something that he heard on the street. He literally testified that he heard around town that it happened, and he couldn't identify the person.
Counsel, I understand that the main thing that you're looking for is an in-camera inspection and a review of your trade secrets claim. Can all of that still happen in the future if we moot this appeal and send it back to the trial court?
Judge, if the appeal is mooted, then Rule 45C might as well be moot, because my clients did not receive any of its protections, and that's what we're here for, particularly because.
How can they receive those protections now, given that they're a party?
They can't, and that's the problem, because their rights at the trial court level were nullified. And that's what we want to try to undo.
But your issue, it seems like your issue really is with the joinder.
The joinder and the subpoena all happened at the same time. So
But
the
we
result.
can't review the joinder, the propriety of the joinder, right?
We can't review the propriety of the joinder, but we can review the propriety of what did not happen during the oral argument, which was the in-camera review, no in-camera review, and no evidentiary.
I don't know how you expect them to do, what was your expectation regarding an in-camera review at that time? Like, had you identified, in particular in response to the subpoena, like suggested that these are the trade secrets in some meaningful way for the court to review, like in camera? Did you bring like a sealed envelope to say, here, Judge, we want you to review these in camera?
No, my clients were there ready to testify in what we thought was going to be an evidentiary hearing. We weren't expecting an in-camera review. We were expecting an evidentiary hearing. And that didn't happen, but I'm suggesting that an evidentiary hearing or an in-camera review was required. And in particular, the motion to join, which is not under appeal, the motion to join happened hours before we were to respond to the subpoena. So that our time to respond to the subpoena was cut short at the discovery deadline to join a non-party to get to documents it exchanged with another non-party for which there is no factual basis, and admissions in deposition saying, we don't have any facts to support the idea that there's anything here. And so this all culminated with Rare Beast not getting its rights under Rule 45C to have any hearing at all or discussion because the trial court said, we don't need to do that, you're a party now. So it's an end run around the rule, and if the court can just do that, then there is effectively no protections of Rule 45C. I think my time is probably close to expiring, and if there's any other questions, happy to take them.
Thank you for your arguments this morning. We'll take the matter under submission and issue a timely decision. Enjoy the rest of your day.